Welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, what your options are concerning the case. The case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanor. Your felony cases are normally referred to as your more serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they are not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the case. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. A person is convicted of a state jail felony. The range of punishment is minimum 2 years. The range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type punishments because, as I mentioned to you, those are felony punishments. You have a misdemeanor case. And misdemeanor cases are divided into 3 categories. We'll start at the top, work our way down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is a fine only, and the fine cannot be above $500. Class C misdemeanors are cases that start in the city court or the JP court. They come to this court when a person is found guilty in the JP court or the city court, and then they appeal their case. And once they appeal their case, they get a whole new trial. And it comes here, and the range of punishment stays the same. It cannot be above $500. Fine only. Okay, the next type of misdemeanor is a Class B misdemeanor. The Class B misdemeanor range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both jail time and a fine. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or a fine that does not exceed $4,000, or you could be given both such jail time and a fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, and the other type is called adjudicated probation. Now, with the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, you will not have a conviction on your record. The case will be dismissed, and you may qualify for what is called a non-disclosure. Non-disclosure means that your record will be sealed to the general public. So the general public cannot unseal the record to see what you was on deferred probation for. Okay. Now, the next type of probation is called adjudicated probation. We had unadjudicated probation. Now we have adjudicated probation. With adjudicated probation, we normally refer to it as regular probation. You do have a conviction on your record. However, if with the adjudicated probation, there's something that is called judicial clemency. What that means is that basically the court can give you a pardon. In essence, they can set the conviction aside, you will no longer have a conviction. Now, when I say the court, I'm talking about the judge has that discretion. Now, in order to qualify, three things has to happen. First, you have to successfully complete the probation. Two, there cannot be any more time left on the probation. And three, you have to be discharged off the probation by the probation department. If those three things happen, then the court has the discretion to set your conviction aside, and you will no longer have this conviction on your record. However, if you get another conviction later on, we call that a subsequent conviction. So if you get another conviction later on, then the case that you receive judicial clemency on can be resurrected, brought back up, and it could be revived, and it can be used against you. And if you try to get a license with CPS, Child Protective Services, then they can deny giving you a license, or they can revoke or suspend your license. Okay, now everyone here should have a clipboard. I'm going to go over that clipboard with you right now. The first document should be not the short document, the first full page document is titled Judge's Explanation of Rights of Defendants Without Attorney. Now, this document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Those are your three options. Now, the first one said the paragraph below number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire your attorney. Okay, so if you want to hire an attorney, the case is going to give you another court date to give you time to hire an attorney. The next one set the paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or ask the court to appoint an attorney to represent you. But before that can be done, you must first fill out a financial questionnaire. Now, a financial questionnaire is also on that tablet. It is a 3-page document that is titled Jefferson County Affidavit Income. This is only for people who will be requesting a court-appointed attorney. So, for example, let's say you want to hire your own attorney. You don't have to worry about this document. Or let's say you want to represent yourself. You don't have to worry about this document. So it's only for people who will be requesting a court-appointed attorney that needs to listen to what I'm getting ready to say. Now, if you're requesting a court-appointed attorney, you have to fill out this document that is titled Jefferson County Affidavit Income. You have to fill out the entire first page. You know, it asks you for your name, your address, date of birth, whether or not you work, you have any children, it asks you for your income information, or whether or not you receive some type of governmental benefits, and it asks you for your bills, like if you have to pay rent, a house note, child support, utility bills. It asks whether or not you have like automobile expenses. Now, when they ask for your automobile expenses, what they're asking for is to not only your oil and gas or maintenance, but it's asking for like if you have to pay a car note, that's an expense. Or let's say you have to pay car insurance. That's an expense. So all of that goes on, you add that up, and that goes on to transportation. All right. Now, you fill out this first page, and then you get to the second page. On the second page, you're going to fill out the top portion that's titled Defendant's Code. And the only thing they're asking for is your name and the day's date. Okay, and your signature. And then you go to the unsworn declaration by defendant. It asks you for your name, your address, the county, Jefferson County where it's executed, and that's it. All right. And this is all you have to fill out. And then you'll stop. Now, going back or referring back to this first document. The next one sentence paragraph below number 3, which is the third one sentence paragraph below number 3, is for people who will be representing themselves. First of all, you have a right to represent yourself. In essence, you can waive or give up your right to have an attorney, and then you can represent yourself. Okay? We call that self-representation. Now, if you are representing yourself, before you can represent yourself, you must first fill out a document. Now, this is only for people who want to represent themselves. If you're not representing yourself, you don't have to worry about what I'm getting ready to say. If you like to represent yourself, you have to fill out a document. It's called a waiver of counsel for purposes of entering a guilty plea or proceeding the trial. This is for people who will be representing themselves. You have to read this document. And basically, the document states that you're aware that you have a right to have an attorney. If you can't afford one will be appointed to represent you, however, you waive and give up your right to have an attorney. And you like to represent yourself. And then you fill out this document, sign on the line that's started the defendant, and you date today's date. And once you do that, guess what? You are your own attorney. And just like your attorney can talk to the district attorney, you can talk to the district attorney to see if you can work out a settlement on you. We call that a divorce. Okay? Now, you can't talk to them if you do not sign that form waiving your right. But once you sign the form waiving your right, you can talk to the district attorney about your case. Now, it says in this one sentence paragraph, you may not speak to the prosecutor unless you first sign a waiver of your right
Tax office.
in this case. All right. Now, this
Emergency
paragraph,
sub courthouse tax office.
yeah. Okay, this paragraph in block form states that be aware that the dangers and disadvantages of self-representation, waiving your right to an attorney and representing yourself may result in the worst outcome for you in your case, including the loss of significant rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, let's say you're representing yourself, and let's say you talk to the prosecutor about see if y'all can work out something in your case. Let's say you want to get a fine in this case. Okay, talk to the prosecutor say I'm not offering a fine. I'm gonna offer probation or something like that. Then you could say this one sentence paragraph states that if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So it's basically saying that, hey, you can change your mind. So you talk to them, you don't like what they're saying, you say, well, Judge, I wanna see if I qualify for a court-appointed attorney. Okay?
Say for instance, we saying our line on a higher.
You can hire too, if that's what you wanna do. But I'm just reading what's on the form.
What's that?
Yeah, we can't stop you from hiring a lawyer because at the top, it states that if you can afford to hire an attorney, you have a right to hire an attorney. But if you can't afford to hire an attorney, you can request that an attorney be appointed to represent you. Okay? Now, at the bottom of this document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Everybody here is going to make a choice. What I mean by that is everybody's gonna put their initials on one of these 5 lines at the bottom. So if you would like to hire your own attorney, then you will place your initials on the first line to the left. You will sign it where it says defendant, dated today's date, July 14th. And then this is the only form that you would have to sign. You would stop and you won't have to worry about anything else. Now, if you have already hired an attorney, then you'll place your initials on the second line to the left. Okay, if you have already hired an attorney, place your initials on the second line, sign where it says defendant. Place today's date, July 14th, 2026, and then you'll stop, and this is the only form that you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left, at the bottom, the third line. And then you will sign where it says defendant. You will date it today's date, 14th of July. And then you'll fill this form out that is titled Jefferson County Affidavit of Indigence. You fill out, again, as I explained to you earlier, you fill out the entire first page. You go to the second page. You're gonna fill out the top portion that is titled Defender's Oath. And then the middle portion that is titled Unsworn Declaration by Defender, and then you'll stop. And these are the only two forms that you have to sign. All right. Now, if you've already been appointed a court-appointed attorney, in your case, or in this case, then you will place your initials on the fourth line to the left, sign the bottom of this form where it says defendant, and you will stop. This is the only form that you would have to sign. All right. Now, if you would like to represent yourself, which means you're giving up your right to an attorney, waiving your right to an attorney, then you'll place your initials on the fifth line, which is the last line, at the bottom of this document. You will sign on the line that says defendant, and today's date, July 14, 2026, and then you'll stop. And then you'll fill out this form that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You'd have to read and sign this document, and then that's it, you'll stop. Do we have any questions before we go on? Okay? You don't have any questions? Now, I need to go over some more rights with you. You also have a right to have, well, let me do this here before I go into the other rights. Now, you could enter one of three types of pleas in this case. You could enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with, and you're gonna have a jury trial or trial by judge. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with, and you would like to see if you can work out a plea bargain agreement or in your case. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. That's what no contest means. So if you plead not guilty, say I did not commit the offense that I've been charged with. If you plead guilty, saying I committed the offense that I've been charged with. Or if you plead no contest, you say I will not be fighting or I will not be contesting the charges. Now, you have a right to have a jury trial. When those young people are sitting in an area, those three people, we call that the jury box. They're shaped like a box, they call it the jury box. And so 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all the evidence that's presented by the state and the defense. They will listen to the arguments of the state and the defense. And then they will go back into the jury room to deliberate. And then once they finish deliberating, they can come back and they can either find you not guilty or guilty. Now, you also have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. If you waive or give up the right to have a jury trial, that just simply means that you will not be having a jury trial. Now, you still can have a trial. You can have what we call a bench trial. And what a bench trial is it's a trial by judge. The reason why they call it a bench trial is because the judge sits on the bench. Okay, so the judge will listen to the evidence that the state presents, the evidence of the defense, listen to the arguments of the state, listen to the arguments of the defense, and then the judge will apply the facts in your case to the law, and then the judge will decide whether to find you not guilty or guilty. Now, you can waive your right to have a bench trial. So if you waive your right to have a trial, either by judge, or say, and by jury, that means that you're entering a plea. In essence, you're either pleading guilty or no contest. And you want to see if you can work out a plea bargain. And if you have an attorney, your attorney will talk to the district attorney's office. Or if you represent yourself, you will talk, you'll see if you can work out a settlement on your case that we call a plea bargain agreement. Now, if you are able to work out an agreement, we call that an agreed plea bargain agreement. Now, it has to go before the judge, and the judge could, accept or reject your agreement. If the judge rejects your agreement, then you have a right to take your plea back. In essence, let's say you wanted to fine, they offer you a fine. Okay, you say fine, it goes before the judge. The judge said, well, I'm not gonna accept that plea bargain agreement. You say, judge, well, since you're not accepting the agreement that I've made with the state, I take my plea back. In essence, I'm not pleading guilty, or I'm not pleading no contest, taking it back or withdrawing. You're the right to do that. Now, if the judge does follow the plea bargain agreement, and if you decide, say within 30 days, that you would like to appeal your case or you want a new trial, and the reason why is in 30 days, you have a right to do that. Then, in order for you to appeal your case, you have to get permission from the judge that follows the plea bargain agreement. Now, if the judge gives you permission to appeal your case, guess what? Your case is gonna leave this court, it's gonna go upstairs on the 3rd floor to the 9th Court of Appeals. There are 4 judges there. They will review the case. And they can either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or if they deny your appeal, so if they grant your appeal, they can find you, find you not guilty, or they can send the case back down to this court with orders. Now, if they deny your appeal, guess what? You can appeal it to a higher court than the 9th Court of Appeals. You can appeal your case to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals located in Austin, Texas. Now, you have to file what is called a petition for discretionary review. I'll explain that to you. What that means is, so say you'll be filing a pro se petition for discretionary review. Pro se means self. I'm not represented by an attorney. I'm filing it on my own. And I'm petitioning or asking the Texas Court of Criminal Appeals to review my case to see whether or not the 9th Court of Appeals committed, should have granted my appeal, or whether or not this court committed error by wrongfully convicting you. The Texas Court of Criminal Appeals can do one or two things. They can grant or deny your petition. Now, if they grant your petition, they can simply find you not guilty, case off. Or they can send the case back to the 9th Court of Appeals with orders, or they can send it back down to this court with orders. Now, if they deny your petition, and at that point, your conviction will stand. Okay. Now, the other right that you have, let's say you cannot reach an agreement with the state, but you still want to plead guilty and no contest. That means you have a right to have the judge to set your punishment. If you don't like what the state is offering, you say, well, I want the judge to set the punishment. You have a right to do that. That's called an unagreed plea bargain agreement. Okay? An agreed plea bargain is with the state, unagreed is with the judge. All right. Now, the next thing is you have a right to have witnesses to come to court. Witnesses sitting in a chair with a microphone is, we call that a witness stand. What witnesses do, they can testify for you, or they can testify against you. If you're representing yourself, you can ask them questions, or if you have a lawyer representing you, your lawyer can ask them questions. We call that either direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses to come to court. What that means, you have a right to say, I'm not gonna call them witnesses. So what that means is, it means that you won't be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. The Fifth Amendment of the United States Constitution gives us the right to remain silent. What that means is the state, the government, the district attorney's office cannot force us to take the witness stand and testify against ourselves. Okay, a lot of times we watch these television shows, about law. You see the television lawyer walk up to the witness stand to ask the witness a question. The witness say, "I take the fifth." What they're saying is, "I'm exercising my Fifth Amendment right against self-incrimination. I'm not saying nothing." You can't make me say nothing. Okay? If you think about it, it makes sense. And I'll explain it to you. Think about it. The state has the burden of proof. The state has to prove that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty, right? That's their job. Okay, so you have a Fifth Amendment right against self-incrimination. Okay, now you can waive or give it up. If you waive or give up your Fifth Amendment right against self-incrimination, that simply means that you will be taking the witness stand. Okay, now the next thing is you have a right to have what is called discovery. And basically what discovery is, you have a right to see the evidence in the state's file, the evidence that they have against you. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings. You have a right to see photos, documents, and whatever kind of instruments that they have, guns or whatever it is they have in your case. You have a right to have access to that. Now, you can waive or give up your right to have discovery. That simply means that you will be giving up your right to have access to it when you waive or give it up. Now, everyone that's here for a case, one, you've been arrested. Well, first one, the charges was filed on, you've been arrested, then placed in a county jail, you're bonded out of jail, you get out of jail on a cash bond, which means you pay the full amount of bond to get out of jail, or you're out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a personal recognizance bond, or a PR bond, which means that you did not have to pay the money to get out of jail. You were simply released under your own personal recognizance, meaning that you was released without having to pay money with a promise to appear and be here. Okay. I've said that to say this. Every day that you spent in jail, that jail time can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. And let's say the state is offering as punishment 5 days in jail. That means you don't have to serve any more time in jail because you've already served 5 days in jail. So you'll be given credit for the time that you've already served. Now, if the state is offering 7 days in jail and you serve 5 days in jail, that means you only have to spend 2 days in jail because we'll subtract 5 from the 7, that leaves 2. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You receive $100 credit for every 1 day that you spent in jail. Okay? Now, the operative word is every day that you spend in jail. For example, let's say you was arrested at 11:59 p.m. or you was booked in the jail at 11:59 p.m. last night. And then you got out of jail 2 minutes later at 12:01 a.m. this morning. You get credit for 2 days. You said in 2 minutes, we get credit for 2 days. Why? Because it's 2 different days. One day was Monday, and the other day was Tuesday. Okay? And so you get credit for those 2 days. Now, if you spend 5 days in jail, that's $500. That can be used towards your fine and court costs. The state is offering fine and court costs of $500. It simply means that you won't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it'll be tax and retired. Now, if they're offering fine and court costs of $700, that simply means that you only have to pay $200 because we will subtract the $500 credit from the 7 and leave 2. Now, you'll be required to pay the $200 on the day that the case is disposed of. However, if you cannot pay it on that day, no problem, because we can put you on what is called a payment plan. And you'll you'll be required to pay off the balance in small monthly installments until it's paid off. Now, let's say we put you on a payment plan, but you do not have the income, we don't have a job or income to pay it off. No problem. We can convert the fine and court costs to community service. So for every 1 hour community service that you perform in a nonprofit organization, $12.50 will be applied to your fine and court costs. So if you work 8 hours one day of community service, that's $100. So if in our scenario, you owe $200 fine and court costs, you work 2 8-hour days, that's paid off because that's $200. All right. Now, Jefferson County has a program for people who have not had charges filed on them, one or more charges. It's called pretrial diversion. With that program, if this is your first time having one or more charges filed against you, they will dismiss your case. Right? You get in the program, they dismiss your case, and guess what? You can get it wiped off your record like it never happened. We call it expunction. Okay, now in order to qualify for the program, as I mentioned to you earlier, that's be your first time having one or more cases filed against you. And then 2, you have to have an attorney to help you to get into the program. The attorney could be a court-appointed attorney. It doesn't have to be somebody that's hired, it could be court-appointed. And then the third thing, it cannot be an offense involving unlawful carrying a weapon or resisting arrest. If you qualify, you get into the program, you complete the program, case is dismissed, you can get it expulsion with deleted, wiped off, erased from your record like it never happened. All right. Now, Jefferson County, when I say Jefferson County, the program, I'm talking about the district attorney's office. They also have another program called Veterans Court. It's for veterans only. So if you're a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. And with the Veterans Court program, it's for veterans only. What they'll do, you get into the program, it could be for any type of case. You complete the program, they will dismiss the case, and you can get it expunged from your record. Okay, erased, deleted, or wiped off. Now, this court, County Court at Law Number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office in March of 2017. The program is called the CSI. CSI stands for Community Safety Initiative. And with that program is designed to address the issue of what we call recidivism. And recidivism means that when people commit crimes over and over. And so in that program, we have partnerships with various agencies in our Jefferson County, our Southeast Texas region. One of the agencies that we have a partnership with is Spindletop, and we have some folks from Spindletop who's going to come in a few minutes and tell you a little bit more about the program. But basically, what Spindletop is our local mental health center in the Southeast Texas region, and they have the expertise to address mental health issues. They have doctors, counselors. They have a partnership with the sheriff department where they have mental health department. And they have various personnel with Spindletop who have the expertise to address mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You could just simply suffer from anxiety or depression or any other host of mental illnesses, and they have the expertise to address those issues. Now, what Spindletop will do today, they can do a private interview either in our jury room, or they can do an interview at their facility, or they can do it by telephone or text, depending on what is comfortable for you. They also will do an assessment. An assessment is meaning they will determine what the mental health issue is, and they will develop a treatment plan to address your mental health issue. Now, if you have issues with alcohol or drugs, well, Spindletop has a drug and alcohol recovery program that is known as ATAR, ATAR is an acronym that stands for Addiction Treatment and Recovery. We also have a program, a partnership that is with our local Drug and Alcohol Council that has a program that is called OSAR, OSAR, which is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both ATAR and OSAR are alcohol recovery programs, and what they'll do, they can do a screening, a private, the screening is basically a private interview, and then they can do an assessment to determine what the drug and alcohol issue is. Sometimes it could be a combination of it could be a combination of drugs and mental illness, which is a co-occurring disorder, so they can address both of those. And then they can they can develop, that is, a treatment plan to address your issues that you might have with drugs and alcohol. Now, if you are unemployed, or if you do not have a better job, or if you would like to have a better job, that is, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Now, Lamar University has a program that is called CICE. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas, they will help you to get a job in the area that you trained in. Now, if you have not graduated from high school, or if you do not have your GED, well, CICE has a GED program, and Spindletop has a GED program, where you could get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we do not just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we could produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2 of Jefferson County, Texas, we don't just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs that I just mentioned to you, just let us know, and we'll be happy to direct you to the person that can get you on the road to living your best life. So at this time, we're going to give you time to finish filling out the paperwork. If you need help with filling out the paperwork, we have our full personnel, including myself, who will be happy to help you fill out the paperwork. Now, once the paperwork is finished, we're going to put you into one of three categories. One category is, we'll put you in the category of wanting to hire your own attorney. And if you're in that category, your case will be reset today, which means you'll be given another court date to give you time to hire an attorney. Now, the second category is if you would like to apply for a court-appointed attorney. Then, if you qualify for a court-appointed attorney, that attorney will be appointed today before you leave. And the last category is if you would like to represent yourself. Then if you like to represent yourself, you're able to work out a plea bargaining agreement with the state. The case will be taken care of today. Okay? Now, it's going to take us a little time for you to finish filling out the paperwork and for us to pick them up. If you need to use the restroom, there are two restrooms right out in the hallway. The main restroom is in front of County Court at Law Number 3, which is right next door. And one of the restrooms is on the opposite side of the hall, in front of County Court at Law in front of the 172nd District Court. And you'll be allowed to go out into the hallways and use the restroom. Please do not leave the courthouse. You leave the courthouse and your name is called and you do not answer, then your bond will be forfeited. Warrant will be issued for your arrest. You will be arrested, placed in a county jail, and guess what? You get out of a bond, you have to pay another bond, and then you get another court date, and guess what? We're gonna have to go through this all over again. So we don't wanna do that. And so once you finish filling out the paperwork, we're gonna call you up one at a time. Oh, on that first document where it says state at the top left-hand corner, it says state of Texas versus, and there's a line. Please print your name on that line. The reason why I say print is because if your handwriting is like mine, sometimes I can't read that. Okay? And so just print your name on that line. So at this time, you need to be mindful that we're still in court. The court is getting ready to go into recess. Do we have any questions? Yes.
Question discovered this.
Hmm?
Usually records for further discovery.
If you have an attorney, your attorney will be given access to a portal. If you're representing yourself, you'll make arrangements with the district attorney.
I was gonna talk about that, but nah.
If you have an attorney, your attorney will have to make that request. Because your attorney is representing you, you're not your attorney. Only way you can get not get access to it if you are representing yourself, because at that point, you are your own attorney. Any other questions? No other questions? Okay, the court is getting ready to go into recess. Oh, no, hold on. Before we go into recess, I forgot. We have some folks here from Spanish Town, and they get ready to take a few minutes to tell you a little bit more about the program that Spanish Town has to offer. I almost got away.
Good morning, y'all. Make it quick. Here, Deputy Butler with Jefferson County Church.
Oh, okay, so yeah, be there.
I'm also the liaison officer for, school time. My partner is a she's qualified mental health professional, also Mr. David, Green. My only point in the defense hospital, if you so happen to become a client and you arrive to the doctor performance back and forth, you know, we want to be doing that. You speak with a qualified mental health professional, you speak with her, Mr. Davis. Okay, hey, I recommend this service. It's not saying that, you know, there's something really wrong. It says it's another source of health. Other than just that fact, and it's a good program, and I just highly recommend it. Ms. O'Tony, she'll tell you just a little more about the program.
Good morning, you guys. As Judge Holmes said, it's just another source of information. We do help with the mental services, we help with substance abuse services. When we say substance abuse, it's not saying, okay, I am overly using drugs. With that, sometimes you guys have cases where it involves classes for you with your substance abuse, or it can just be some information for you. With our mental services, it is purely just to get help. It's not saying there's anything wrong with you or you're having any issues within, you know, yourself or family, but we can give you information. With Judge Holmes, he will go ahead and get you guys to fill out the paperwork. We have a little short form that's included in the documentation that Judge Holmes gave to you guys. With that, we have assistance with housing, we have assistance with GED, as well as if you would like to get college courses started. It's just like I said, a source of help. Anything that you guys also provide us, we are provided, protected by HIPAA. The only thing that if you guys do inform us that we have to report would be anything as far as suicide issue. Other than that, anything you guys know, it's strictly between us. We'll give you a moment, Judge Holmes will go ahead and do the paperwork. And if you would like to speak to us one-on-one today, we're available. We also do quick message phone call, or email, whichever is more convenient for you. Any questions for me?
Okay. Thank you.
Yes, you know.
Okay, thank you, Deputy Butler, Mrs. Gray, and Tanya. Okay, now, ladies and gentlemen, again, we have our co-personnel here. We have finished with our paperwork. What they're gonna do. They're gonna tell you how to get it in line, and then they're gonna call you up, they're gonna put you in the three categories that I had, mentioned out. What I also need to mention, if you have a case involving family violence, then we have, family services, Mr. Johnny Stewart, usually from Family Services. With that program, that's also part of the child virgin program, and, you'll, if you qualify, you get into a BIP program, balance intervention and prevention program, that's what it's called, BIP. And what they'll do, once you finish the program, this is special case. I can never happen. And if you're an assault, then, you can take what's called anger management, that's also part of the pretrial diversion programs. And when you get in that completed, they'll dismiss your case, okay? So those are, programs that, that's available. At this time, we have our core personnel. Right, chilling. Okay, they're gonna call the name. You're gonna call them up? Okay. Not call them up, you know, call them to come, to line up.
If you're done, with your clipboard,
Jefferson County Court, law number 2 is back in session. The court is in session and cause number 26 CCCR 1338. Case is filed the state of Texas versus John Prentice Hill. Mr. Hill, your full name is John Prentice Hill? Mr. Prentice Hill, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Hill, you may put your hand down. How are you doing, Mr. Hill? Doing all right? That's good. Now, Mr. Hill, you're represented in your case by your attorney, Charles Rojas. And Mr. Rojas, how are you doing?
Doing well, Judge, thank you.
Ms. Rojas, do you waive a record in Mr. Hill's case?
We do, Your Honor.
The state is represented in this case by attorney Cornelius Williams. Ms. Williams, how are you doing?
Very well, Your Honor. Thank you. And how are you and your exceptional staff?
We're doing great. Thanks for asking.
You're
Mr. Hill, I have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, John Prentice Hill, on or about April 15th of 2026, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100, but less than $750. Mr. Hill, do you understand what you've been charged with?
Yes,
To this charge, how do you plead? Guilty, not guilty, no contest.
guilt.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you are guilty?
yes,
Mr. Hill, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes,
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant?
yes, sir.
At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand this statement?
Yes, sir.
The next box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendants? Mr. Hill, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes,
And did you understand everything in these documents?
yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, sir.
Mr. Hill, are you a citizen of the United States?
Yes, sir.
State tender to this honorable court, State's Exhibit Number 1.
No objection, Your Honor.
No objection. States Exhibit Number 1 will be admitted. Mr. Rojas, you advised and counseled Mr. Hill. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Hill, your attorney, Mr. Rojas, has advised and counseled you. Are you satisfied with his services?
Yes, sir.
Mr. Hill, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The essential terms are as follows. It will be 40 days within a Jefferson County jail, time served, time actually served, and our court costs should be taxed and retired. Is that correct, Mr. Rojas?
That's correct.
Mr. Hill, the state is offering that you serve 40 days in Jefferson County jail. However, you not have to serve any more time in the Jefferson County jail because you've already served 40 days in Jefferson County jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Hill, do you understand the state's offer?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Hill, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Hill, if you do not have anything else holding you in jail, you should be getting out of jail today. Mr. Hill, you're going to stand next to the bailiff, follow her directions. Once you finish following her directions, you can follow the bailiff, and you have a blessed day.
Yes, sir.
And Mr. Rojas, you have a blessed day as well,
Thank you, Judge. You
and
too.
you're free to go. You're welcome.
Take care of this.
We should thank
All right, Mr. Holmes, please. Yes.
Yeah.
Oh, when you get out.
Okay,
You have to go to one, two, you already, and then. It'll be French. Back. Yeah, so you get out.
Hey, I'm gonna send this Freddie back to you. Send it back to me. Okay.
Fine.
your first name?
Corey.
Shakur?
Yeah.
Mr. Chavis, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
That's right.
Mr. Chavis, you may put your hand down. How are you doing, Mr. Chavis? That's good. Mr. Chavis, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line that's titled defendant?
Yes.
Or these your initials on the line that state you like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Chavis, I read your answers. Your case will be reset to give you opportunity to hire an attorney. Stand in front of our court administrator. She's gonna give you reset. Once you get your reset, you're free to go and you have a blessed day. Here you go. You can make that after that. Fernando Cabrera. Okay, this is cause number 26CCCR 1468. Case is style of state of Texas versus Fernando Cabrera. Mr. Cabrera, is that your full name?
Yes, sir.
Mr. Cabrera, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Cabrera, you may put your hand down. How are you doing, Mr. Cabrera?
I'm good. How sure?
You doing good? That's good. Now, Mr. Cabrera, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you would like to apply, that you would like to hire your own attorney? Now, Mr. Cabrera, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Cabrera, your case will be reset to give you an opportunity to hire your own attorney. Our court coordinator will give you a reset, but before she gives you a reset, I need to give you some bond conditions. Bailiff is gonna hand you a document that is titled Standard Bond Conditions in County Code Law Number 2. I'm going to go over these bond conditions with you. And it states that following return of a criminal conviction in County Code Law Number 2, all bail bonds are executed for release of any defendant named herein or order subject to the additional condition. Number one, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number two, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol when the test indicates the presence of drugs and alcohol in the defendant's body. You understand that condition?
Yes, sir.
Now, condition number 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, Your Honor.
Now, if you violate any one of these bond conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, Your Honor.
Now, you can get your copy of your reset from our court administrator. Once you get a copy of the reset, you're free to go, and you have a blessed day.
This is the cover right here, isn't it?
Yes. Yes.
Oh, you already have it? Okay, yeah, you're free to go. You have a blessed day. Shason Carmouche? You pronounce your name, Chason?
Chase.
Chason? Okay, Mr. Carmouche, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Carmouche, you may put your hand down. How are you doing, Mr. Carmouche? That's good, Mr. Carmouche. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, good.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant signature. Is this your signature? Mr. Carmouche, before you sign and initial these documents, did you read the document?
Yes.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Carmouche, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Christy Carlton. Attorney Carlton will be given information to contact you, and you will be given information to contact her. Court administrator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
I apologize to them. What's his name, Your Honor?
Carmouche? Next case is Trace Jerome Guillory. Mr. Guillory, your full name is Trace Jerome Guillory.
Yes, sir.
Mr. Guillory, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Guillory, you may put your hand down. How are you doing, Mr. Guillory?
Good, are you?
I'm doing fine, thanks for asking, Mr. Guillory. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Carmouche, before you sign and initial these documents, excuse me, Mr. Gillard, before you sign and initial these documents, did you read the document?
Yes, sir.
And did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Guillory, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney William Wilkerson. Attorney Wilkerson will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information, you'll be free to go, and you have a blessed day.
Yes, sir.
All right. Darrell Martin. Hey, Mr. Martin, your full name is Darrell Martin.
Yes, sir.
Martin, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Martin, you may put your hand down. How are you doing, Mr. Martin?
I'm fine, you, sir.
I'm doing fine, thanks for asking. Mr. Martin, I have two cases before me. I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And is this your signature on page 2 of this document above the line that's titled Defendant?
Yes, sir.
Now, Mr. Martin, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Martin, I read your answers. Based on your answers, meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Giles Cole. Attorney Cole will give information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you're free to go and you have a blessed day.
One question, I fill out a paper to speak with the spelling top for the veteran.
Okay, you picked up that paper? Is it on this clipboard? You have your clip?
Yeah,
Did you have,
Yeah.
No, you filled it out.
It's received.
are they still here?
okay, I have to do it.
They can, they're gonna contact you.
Okay.
If your phone number and everything is on
Yes, sir.
Okay. You need to make sure, okay. it. Preston Wade Haynes. Okay, Mr. Haynes, your full name is Preston Wade Haynes?
Yes, sir.
Mr. Haynes, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Mr. Haynes, you may put your hand down. How are you doing, Mr. Haynes?
Pretty good, you?
I'm doing fine, thanks for asking, Mr. Haynes. You're represented in, well, Mr. Haynes, I have before me two documents. First document is titled. What happened? Would you need me to fill something out?
Are you expecting?
Why don't you go get him? She don't have his phone.
Oh, they have. No, it's in the thing, put in the grab it next week. Oh.
Okay. Mr. Haynes, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Haynes, you may put your hand down. How are you doing, Mr. Haynes?
Pretty good, you?
I'm doing fine, thanks for asking. Now, Mr. Haynes, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
It is.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled, what is this here? Okay, I have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Okay, yeah, I can't advise you, but I will give you base
I need to go back over this one. Yeah, and is this your signature on the line that's titled Defendant? And, now, Mr. Haynes, before you sign these documents, did you read the documents?
I did.
Did you understand what you read?
Yes,
And is everything in these documents true and correct
yes.
to the best of your knowledge? Now, Mr. Haynes, I need to go over some, let me look at this here. Oh. Now you work at, Monday, is that Monday Companies?
Yes, sir.
Okay,
Good year plan.
I have been in staff. James Madison.
okay, let me do this. I'm gonna ask you some questions. Okay, if you wanna hire your own attorney, we'll reset your case to give you time to talk to some attorneys. Okay? Did you hear that? Yeah,
Oh, it's changing it.
no, well, yeah, he's gonna have to, I'm gonna have to give him his paperwork. So he can make that, they did. Right, do that.
Market right there, and what is that? Market, and you want to initial there. I want to do that, mark out again, mark out. Yeah.
There's somebody on there, Tanisha Land. Okay. Okay, you can, get your reset from our court formula. Yeah. I had it. I just saw you. Yeah. Yeah. What I did, I just saw it was you. Huh? You talking about these here? The people that's it. On apartments, all these other people wants to. Now, that's a dismiss, okay, I'm gonna do that dismissal on a land. In the same, you already have Freddie, right? Yeah, his.
So, what are we doing with Freddie? Is it being?
Dismissed.
Over here, okay.
Both of them was dismissed. They were dismissed.
I wonder if our felony is going.
Dismissed.
When?
I think they pled on a 1 day something sanction. They just kept on probation. Okay. That's it. Mhm. What dismissals? They're not here. Who is it? No, that's Felicia Freddie and that's out of date. I think they had felony cases.
Okay.
That was the Gertz was representing Freddie. He just told her to leave. Guy. Yeah. Yeah. Oh, Wells. That person might. Ashley Wells? How you doing, Ms. Wells? That's good. Ms. Wells, let's see, where is this? Oh, here it is. Ms. Wells, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document.
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials that state you like to waive your right to an attorney to represent yourself?
Yes.
I also have another document that's titled waiver of counsel for purposes of entering a guilty plea or proceeding trial. Recognize this document?
Yes, sir.
And is this your signature on this document? Before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Now, Ms. Wells, I have before me a motion to dismiss your case. Is that correct, State?
That is correct, Your Honor.
Okay.
The state does not believe the substantive ends of justice would be satisfied by the continued prosecution of this matter. Thank you very much for your time.
Thank you.
Hey, Ms. Wells, I'm signing the dismissal. You'll be able to get a copy of the dismissal from our court coordinator. Once you get a copy, you're free to go. You have a good day.
Yes, sir.
That's it. Oops. It's just timed out. Hold on.
I know with this new update, this thing
Yeah.
keeps timing out.
Court is in session in cause number 26 CCCR 1344. Case is styled the state of Texas versus Brendan Alexander Allison. Mr. Allison, is that your full name? Ms. Allison, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Allison, you may put your hand down. How are you doing, Mr. Allison?
I'm doing a good job.
I'm doing fine, thanks for asking, Mr. Allison. I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes,
Mr. Allison, before you sign and initial these documents, did you read the documents?
yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Right.
Mr. Allison, I read your answers. And state, I have before me a document that is titled Motion to Dismiss in Mr. Allison's case. Is that correct?
That is correct, Your Honor. There was a issue in reference to, there was an accompanied felony matter, Judge, that it was resolved in January of this year. And it was a 12.44 of the Texas Penal Code, where the state jail was sentenced as a misdemeanor, you judge.
Okay,
The other issue was, this matter was to have been dismissed, but the ADA is no longer, has been with the office, and there weren't any other notes. And it's the state's position that the substantive interests of justice probably would best be served
okay.
by the dismissal of this matter.
Okay, now, Mr. Allison, I just signed a dismissal. You will be given a copy of the dismissal by our court coordinator. Once you get a copy of the dismissal, you're free to go and you have a blessed day. Right,
Appreciate
stand right here. You are.
Good luck to you, man.
Thank you.
Okay, who we have?
That's
This,
all I need.
that's it.
We can call Mr. Livings and
Okay, Christopher Livings. Mr. Livings, I have two cases before me, cause number 25 CCCR 2788 and cause number 25 CCCR 0596, excuse me, 0665. Let me do that again. Cause number 26 CCCR 0696. Both cases are styled the state of Texas versus Christopher Dante Livings. Mr. Livings, is that your full name? Mr. Livings, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Livings, you may put your hand down. How you doing, Mr. Livings? You doing all right?
Yes, sir. Very professional.
I'm doing fine, thanks for asking. Mr. Livings, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for corresponding attorney? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Livings, before you sign and initial these documents, did you read the documents?
Yes,
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Livings, okay, I've read your answers. Now, state, what's the state's
the
position?
state made an offer which was rejected by Mr.
Livings?
Yes, sir, Judge.
Okay,
Well, like, it's my first offense, so I don't really know what's going on.
what was your question?
This is my first offense, so
Okay,
I'm not like, I don't know how this works, but, I was trying to see if I could get like probation or anything, cause I currently, I don't live in Beaumont, and I stay in Waco.
ooh,
I think the last time I talked to you was on Zoom.
Okay, you couldn't have been, yeah, we actually, you had to come down here in person to sign the paperwork. Okay. Um. So, in terms of, hiring an attorney, well, in terms of, having an attorney to represent you, or your right to have an attorney, you have three options. Number one, you can hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. And I see here that you wanted to represent yourself, but you did not accept the offer that the state has given it to you, has made to you. Is that correct?
Well, yeah, cause I was told that, I might get the case be time served, cause I was in jail, the day after Memorial Day. I went to jail in Mid County, and, they transferred me out here.
In Mid County?
Yes, sir, I was in jail in Mid County. Waco.
Oh, yeah, Waco, you was in jail. Oh, when you say Mid County, we call Nederland, Texas, Mid County.
Oh, no, sir, Mid,
Oh.
Mid County. It's the county out there.
Oh, that's what it's called?
Yes, sir.
Hold on a minute, let me look at something. Let me see, his name is Christopher Livings. Let me see if there's anything in the computer on that. How long you stayed in jail
I was in there for like, it was the day after Memorial Day, and I didn't get out until like July no, I got out at the end of June. It was like,
Memorial Day was in.
I mean, not I'm sorry, it was, I know it was, I was in there longer than 2 weeks. 'Cause
Okay, hold on a minute.
I had waited a week.
Oh, did you bond out there?
Out here, I couldn't bond out.
No, did they bring you from there here?
Yes.
So they had a whole.
Transport bus.
Okay, let's see what we got. Summary. Okay, let's see. Here we go. Okay, so they say that they received a teletype subject is in custody in M's. It says M County Sheriff's Office Jail. Now, what's the name of that county?
It's Mid County.
Mid?
It's Mid County or
Mint?
Mid, it's MC County or something.
Oh.
I'm not too sure.
Okay. No local.
McClendon County is Waco.
Is that what it is? McClendon? So
Yeah.
they call it Mac. Okay. Okay, so on May 26th, our sheriff's office received that he's in custody, I guess, in McClendon County. No local charges will send teletype when ready for pickup. Okay, set to up the transport. That's the next day.
What we don't have, Your Honor, is how he came into contact with the law enforcement in McClendon County in the first place. They just didn't go out.
Unless they had a warrant out on it.
There was a warrant, but there still have to be some contact for that warrant to pop, Judge. You with me?
I mean, yeah,
Like a traffic stop.
it could be a traffic, just any stop.
I was in my apartment when I got arrested.
Oh, so they came to his house on a warrant.
Not on a criminal trespass.
Oh, I don't know.
Cause
No, I'm saying
The girl-
that doesn't make sense.
the girl that I'm talking to out there, me and her, she's pregnant, so I wanted the DNA test, and we got an argument.
Okay, so they called the police, they found out you had a warrant. Okay. Receive KPS. How much jail time he has here? Does it say when could you look up to see when he got to the jail here? Cause I can add up from May 26th. They received a teletype on May 26th. 2026. Resign Frank. Surety bond. Okay, you posted a bond
Yes. sir.
on May 5th of 2026. So you was in jail from, and we know from May 26th to April 5th.
Yes.
Okay.
You said May 26th, you said April 5th, Judge.
Oh, so I mean to June 5th.
Okay.
June 5th.
Yes.
Yeah, May 26th of 2026. That's when our county received notice that you were in McClendon County's jail. And then you bonded out here. Hmm? Okay, so he bonded out on June 5th, is that correct? Okay, so how many days is that? The 26th through the 5th, 9, 10, 11. You got a calendar?
Sorry, Judge. So I heard you, when you talking again, about the first offense, like,
Or if you've never been in, yeah, that's only problem is you live out of county. You talking about for the pretrial diversion? Y'all don't offer pretrial diversion for people that lives out of county, do y'all?
If
Do
you
y'all do?
going to, let me say this unequivocally, Judge, so we're not wasting any time. Yes, you can be out of county to get a pretrial diversion. You have two matters that's before you right now. They're both in domestic nature, and I submit to this court. From what he just told the court judge, he was arrested on a new offense. He cannot have any other arrest. And I'm pretty sure, based upon what he said and the amount of time that he spent in jail, he was arrested in McClendon County. With that arrest, this is not his first offense, Judge. He would not qualify for the program.
this,
Okay.
but this is my first offense.
Yeah, but what he's saying is that you probably got arrested in McClendon County for maybe a domestic or family violence issue.
Not at all.
And they probably have, I don't know,
Is it a way I could search that? Cause that's not the case.
I don't know how you can search you. You'd have to contact McClendon County, I guess. Because McClendon County would know what you were arrested for.
So she must have called.
Well, no, it was a call, but I was talking to the police officer and
I know, well,
they grandma, they
Yeah.
asked my name and then they seen that I had one, so they took me.
oh, okay.
So he didn't get a new charge. I
Yeah,
mean,
it
that's what
wasn't,
he's saying.
it wasn't on the charge.
He went to jail because he had a warrant.
Right, okay.
It was active.
Wow, yeah, you inside the state of Texas, let me see. So, I don't know, I mean, if you talk, I mean, you mentioned time served, it looks like you,
Well, that's what I heard.
yeah, I mean, that's up to the state to offer what they want to offer. We don't have no control over the offers that, they make in the case.
Yes, sir.
Okay, now, these are two criminal trespass cases. Which means the range of punishment is minimum. You could get up to 180 days in the county jail. They class B misdemeanors. Okay, and you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Okay.
Yes, sir. So is it too late for me to get an attorney?
No, I think the paperwork states that you could change your mind at any time and request that an attorney be appointed to represent you, or you can hire your own attorney.
Well, you think it's best for me to get an attorney?
I can't give you no legal advice. I mean,
Yeah,
as a judge,
this is my first time. So I don't.
I understand, but I'm just letting you know what your options are.
Yeah, I like the attorney. Yeah.
You like this, what is court appointed? See if you qualify for court appointed?
Yeah.
Okay, just have a seat. She's gonna give you some paperwork to fill out. Miss Mosby, you're gonna put this on there too. Okay, the next person.
Mr. Grant?
Grant, Wallace Lee Grant. Mr. Grant,
Yes, Your Honor.
your full name is Wallace Lee Grant.
Yes, Your Honor.
Mr. Grant, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Grant, you may put your hand down. How are you doing, Mr. Grant?
Doing pretty good.
That's good.
To you.
I'm doing fine, thanks for asking. Now, Mr. Grant, I have before me document that's titled Judge's Explanation of Rights to Defendants Without Attorney. And Mr. Grant,
Yes,
do you recognize this document?
I do.
And is this your signature online as titled defendant?
Yes, sir.
And are these your initials online that state you like to waive your right to an attorney to represent yourself?
Yes, sir.
I also have another document that is titled waiver of counsel for purposes of entering a guilty plea or proceeding the trial. Do you recognize this document?
Yes, Your Honor.
And is this your signature? Where is it? Right here. And is this your signature online as titled defendant?
Yes, Your Honor.
Mr. Grant, before you signed and initialed these documents, did you read the documents?
I did.
Did you understand what you read?
I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Grant, you had an opportunity to talk to the prosecutor
I did.
and Mr. Williams?
Judge,
What was-
there's an accompanying DWI M262114 that arose out the same set of factors showing that it's received within the office, Judge. That forms the basis of the possession of the UCW.
Oh, so you did
And
have-
we have not got back to.
Okay, so they filed one before the other one
Yes, Your Honor.
again. So basically, what the state would like to have that other case so they can wrap all this stuff up, all these cases together. Okay,
Yes, sir.
and so what we're gonna do, we have to reset your case.
Okay.
To give them give them time to review the case. See if they will accept it. Now, let me tell you this,
Yes, sir.
Mr. Grant. Sometimes it takes a while for them to file the case. When I mean a while, it could be a couple of months. Okay, because on DWI cases, sometimes they have to send it to a outside lab
Yes, sir.
for the analysis, and that lab is testing all of the cases in the state of Texas, and you can imagine how big the state of Texas is, right?
Right.
So that's why it takes a while,
Yeah. Biggest state
right?
by
And-
land, second to Alaska. Yes, sir.
Yeah, that's right, in landmass. Now, what we're gonna do, we're gonna reset your case. Oh, what I need to do, I need to give him some bond conditions. She has to make a copy. You can make it from right there.
Yes, sir.
Here you go. You could make them right there. Just stop, right. That's that door. Okay, give mostly, you can hand this to him. I'm going to go over this document with you, Mr. Grant. The
Yes,
doc,
yes, Your
the
Honor.
document is titled Standard Bond Conditions in County Court at Law number 2, and it states following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas. All bill bonds executed for release of any defendant named herein or order subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, Your Honor.
Okay, condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
Now, condition number 3 and condition number 4 do not apply. However, condition number 5 does apply, and condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, Your Honor.
Now, Mr. Grant, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You will be arrested and placed in the Jefferson County Jail. Now, Mr. Grant, you will be given a copy of your reset. Your case is going to be reset. Once you get a copy of your reset, you'll be free to go.
Yes, Your Honor.
And you have a blessed day.
I
Oh,
got
there
a
it is.
couple of questions. My wife possessed firearms. We live in the same house.
Well, that's the problem. They say you cannot own or possess. Okay? I think that's, let me read it again. The defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Yes. So you may need to talk to a lawyer about that, but these are our standard bond conditions. Okay?
Yes, sir. Next question.
Okay.
For court appointed,
Okay.
is there a salary?
Well,
Is
we-
there a condition, a range?
No, what we normally do, we look at your salary. Look at your salary and expenses. And then once we look at that, we can determine whether or not you're eligible. We have enough money to hire your own attorney or not.
Okay.
It's your salary plus your spouse. They ask for that on the
Okay, plus the
paper.
spouse, so I.
That's all that base is, I guess, a combine of the household.
Yeah.
Right.
Okay.
Okay. Yeah, that's in the form.
Yeah.
All right. So you got your reset. If you have your
Yes.
reset, you're free to go.
Okay.
And you have a blessed day. They're gonna, your case may be reset a couple of times.
I'll,
To get him opportunity to file a case. We just don't know. They may have it filed by the next reset. I don't know.
that'll give me a chance to look over discovery and see if I should continue to represent myself.
Yeah, you can do
or my
that.
attorney.
Oh, that's true. All right.
Can I ask him one question?
Yes.
Is it possible to get the toxicology report?
They don't even have that
one.
yet.
We don't
Oh.
have one yet.
Because the case ain't been accepted.
Sir.
It
No,
hasn't been
that's what I
accepted.
showed, nothing is in yet.
Okay.
Yeah, it's not accepted.
Thank you.
Yeah.
Thank you, guys.
Yes, sir.
All right.
Yes, thank you.
All right.
Mr. Williams.
All right.
You guys have a good day.
All right. Thank you.
You're so welcome.
Michael Ivy. Okay. This is cause number 26 CCCR 1450, case of Styles of State of Texas versus Michael Lee Ivy. Mr. Ivy, is that your full name?
Yes, sir.
Mr. Ivy, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Ivy, you may put your hand down. How are you doing, Mr. Ivy?
All right, how about you?
I'm doing fine, thanks for asking. Now, Mr. Ivy, you are, well, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes,
Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to an attorney to represent yourself?
yes,
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Mr. Ivy, before you signed and initialed these documents, did you read the documents?
sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes,
to the best of your knowledge? And Mr. Ivy, you had an opportunity to talk to the prosecutor, is that correct?
yes, sir.
And Mr. Williams?
Yes, Your Honor, the state tendered, an offer of deferred adjudication. He may have questions for you, Judge. By obviously not, giving him any advice, it appears that he will qualify for the pretrial diversion program.
Okay, so that's the option.
He
You know,
doesn't-
I mentioned that earlier. You have an option. If you would like to accept, you could accept or reject the state's offer. Now, if you accept the state's offer, they'll go forward on what they offered you. If you reject it, he said that they have on as an option pretrial diversion. And you can make a choice. I can't tell you what you should do because I can't give you any legal advice. But those are your options.
Well, I feel like, the option I was given was not for like a first offender, first offense.
Oh, okay. Well, what you mean the options that you was given? You talking about the offer?
Yes,
Okay, so he offered
Deferred.
Deferred probation. It's unadjudicated probation, which means that if you successfully complete the probation, you don't have a conviction on your record, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. That's what the unadjudicated probation is. Okay. The other option with the pretrial diversion, with that option, you get into that program, you complete the program, they dismiss the case, you can get it expunged, which means removed from your record. Those are your two options. Okay?
yes, sir.
So that's up to you. And I don't know what you're saying for first time. I don't know what, I mean,
Like the DWI, first offense.
okay. I mean, let me tell you this here. Whether it's your first offense, if it's your first offense, the range of punishment is minimum 72 hours in jail to a maximum of 180 days. They can offer you anything within that punishment range. 72 hours in jail, all the way on up to 180 days in jail. You could be given a fine that does not exceed $2,000, anywhere within that range. Okay? So, or they can give you, they can offer you probation. There are two types of probation. I mentioned to you earlier that there's a deferred unadjudicated probation, and there is a regular probation. The difference between the two, with the regular probation, you have a conviction on your record. With the unadjudicated probation, they call it deferred, you don't have a conviction on your record. I mean, those are just your options. I mean, so like I said, I can't tell you what to do or not to do. That's your choice. You still had an option where you can hire an attorney and see if you qualify for a court-appointed attorney, or you can represent yourself. Those are all of your options. I'll get an attorney.
Okay, that's fine. Let me do this here. Ms. Mosby?
Yeah.
He needs to, change this. He gonna change this to hire. Okay,
All right, mark that one out and the first one.
okay. Now, okay, if you change your mind, you state you wanna hire an attorney to represent you, is that correct? Okay. Okay, your case is gonna be, your case is gonna be reset. Once your case is reset, you're free to go. And you have a blessed day. Okay, thank you. Oh, you're gonna go over here.
Just have to see if I can come.
Here you go. Okay. Oh, where's Mr.? That's right. Mr. Livings. Mr. Livings? Okay, now, Mr. Livings, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. And you place your initials on the line.
Yes, sir.
And is everything in this document,
Yes, sir.
and is everything in this document true and correct to the best of your knowledge? Mr. Living, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Jennifer DeLage. Yes, Ms. DeLage will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, Mr. Livings, you'll be free to go.
Yes, sir.
And you have, let's say, yes, you was getting ready to say something?
Yeah, well, like, so, I mean, me talking to the attorney, will she be able to help me, like, get in the program with the first offense?
Yeah,
Okay,
yeah, but you need to tell her that.
okay.
Yeah, make sure you mention that to her. Okay. Mr. Livings?
Yes.
You get your reset from our court coordinator. Once you get your reset, you'll be free to go. You have a blessed day. Please have a seat in that first chair on the wall.
Thank you.
You're welcome.
We have any,
Hold on,
I'm
I'll
sorry.
check.
yes, sir.
Now the last thing we did is, you know, that we go, you know, we played, this afternoon. Where we can see some of the station. I can see you can back it tomorrow. You were very big deal. Yeah, I'll go through it.
Okay.
That's, Jennifer DeLage.
Yes.
What?
Thanks. Yes,
Let's say, almost, you know,
come on up.
That's it, something.
with
Yeah,
the time that,
Luckily,
the time that I spent in jail, that doesn't,
that, you'll be given credit on that.
okay,
Yeah, talk to your attorney about that.
okay.
Yeah, and she can, find out how much you did in the other county too.
Okay,
Yeah,
yes, sir,
but you need to make her aware of that.
yes, sir.
Okay. Okay. Let's see. What did we